Do you want me to start? Okay. Thank you so much for that introduction. And thank you to Professor Yufan for inviting me to participate in this gathering. It's such an honor to be here with such a distinguished panel of other professors and people engaged in the field of fighting forced labor in supply chains. Today, I want to draw on over 20 years of research of mine on labor migration and forced labor in supply chains, as well as my recent study of the forced labor import ban in the United States. I want to trace today how forced labor arises in global supply chains, focusing on the seafood supply chain in particular. I want to discuss the U.S. government's application of its forced labor import ban in seafood and in other industries. And then I want to conclude by recommending steps the Taiwanese government might consider taking to lower the risk of forced labor in export industries such as seafood, with two goals in mind. First, to protect migrant workers in those industries. And second, to ensure that goods from those industries are not subject to trade bans and other kinds of sanctions. So let me start by outlining how forced labor arises in a supply chain context. And I should say that in my experience, it's very common that when we talk about forced labor, we discuss it as a problem of individual bad actors. So in seafood, for example, we blame the outlaw captain who's violent toward the crew or who holds crew members' passports. We blame the corrupt labor recruiter who takes bribes and makes false promises. Thank you. And that perspective, the perspective of the individual bad actor, leads to interventions that are localized. They target just the bad actor. And of course, it's important to punish and deter individuals' illegal behavior. But where the forced labor continues to recur, even where we have an individual punishment regime, it's likely that it's arising from a larger economic system. And it's likely that to fix it is going to require interventions that target the broader dynamics that bring the forced labor into being over and over. So I want to turn now to those dynamics using the seafood industry globally as an example. And I'll begin by talking about my country, the United States. The United States is an enormous consumer of processed seafood. As it says on the slide, we imported 230,000 metric tons just of processed tuna just last year alone. And we import a lot of other kinds of processed and unprocessed seafood as well. And where consumers like me get that seafood in the United States is from a very small number of very large stores. And these big stores, the retailers, have very few competitors in the United States. They're where most people buy their seafood. And that fact gives them a great deal of economic power. And they use that market power to demand low prices from the brands that market seafood according to their name. So the brands are forced to lower their prices in order to compete for shelf space in the large retailers. But meanwhile, the brands have quite a lot of power themselves. So the brands are sourcing seafood from multiple production countries. And within those countries, they have a lot of power because people want to sell to them. And so that allows the brands to turn around and push the demand they receive from the retailers down onto processors and brokers and traders in seafood countries of production. And particularly these large brokers that you see on the middle of the production country part of the slide have a tremendous amount of economic power themselves within each individual production country. And this puts them in a pivotal position. Yes, they face the accumulation of all the demands for low price in the actors above them in the supply chain. but they have the power to take those demands and turn them down, further down the supply chain to the vessels that actually sell the seafood at the bottom. And so these brokers are able to sell at a lower price because they can demand a lower price from the vessels at the bottom. And by the time we get to the vessels at the bottom, the amount of profit available to them because of the accumulation of all of these economic demands is pretty slim. And so they are looking, the vessel owners are looking for every possible way to cut costs. And an obvious way to cut costs is by cutting the price of labor. Labor, along with fuel, is one of the major expenses for a vessel owner. And so they are looking for ways to get workers at the lowest possible price. And the lowest possible price for workers is rarely the price of local workers. Usually, it's the price of migrant workers in another country. So here we have adding in a migrant origin country. Governments in countries of production respond to the demands of businesses in their country, for example, vessel owners, for a cheaper labor force by creating visa programs that facilitate their employers' access to workers abroad. So these workers are looking for work, and the vessel owners are looking for workers, but they rarely have a way to contact each other directly. Instead, the vessel owner's decision to hire migrant workers requires that the vessel owner connect with what I call the human supply chain. So we're, I think, more familiar when we talk about supply chains with what I would call the product supply chain. That's everything on the top part of the slide, from the actual harvesting or sourcing of the good or product, all the relationships that bring that product to its market. That's the product supply chain. The human supply chain, by contrast, but also kind of the same, is the set of relationships that bring human beings from their home country to work in another country. And just as the demands of lead firms in the product supply chain drive down costs at the bottom and create a desire, or maybe I should say it this way, all of the demands for lower cost ultimately fall on the vessels at the bottom of the product supply chain. Likewise, all of the demands for low cost and also payment ultimately fall on the workers at the bottom of the human supply chain. Okay, so how do the vessel owners find the workers? Their first stop is usually a manning agency in their own country. And the manning agency in their own country has relationships with manning agencies in migrant origin countries. And at the same time, now, even though we have a relationship in the migrant origin country, the workers are rarely directly in touch with a lead manning agency. Instead, they're going to hear about work opportunities from people in their community. They may hear about it from Facebook. And the first point of contact for them is going to be a local sub-agent. So local sub-agents at the bottom of the supply chain have status in their communities. They have the trust of migrant workers, mostly or quite often in remote areas. And that makes them invaluable to the supply chain as brokers to connect workers to employers. The chain continues above them. They connect workers to agents. The agents connect them to the manning agency in the origin country, and so on up to the vessels, where the manning agency in the production country places them for work. Economic pressure, as I've said, builds as we go down the human supply chain and lands on the workers at the bottom. Because the employer, the vessel, doesn't pay for the costs of recruitment, the manning agencies at the top take money from the manning agencies in the origin country. That manning agency demands money from the lead agents and they from the sub-agents. And all of those demands for money come to land on the migrant worker, him or herself. And what that means is that in order to get access to work on a vessel, the migrant worker is going to have to face payment demands all the way up the human supply chain. And this is going to include both legally permitted fees and costs and also bribes and illegal charges. And to fund those expenses, which are far more than most migrants have the capacity to earn in their home countries, they're going to borrow money. Often they don't have access to formal borrowing mechanisms, and so they're going to borrow informally at very high interest rates. People who are seeking to migrate want the work which pays more than other options that they have in their home countries. And so that, plus the fact that recruiters not uncommonly misrepresent how much you can earn in the production country and what the conditions will be, make people believe that their earning power is going to be greater. And so they're willing to take on even more debt than they otherwise would. And the result of all of these interactions in the human supply chain is that when migrants enter the production country, they do so with very high debt levels. And debt is a major risk factor for forced labor. I would put it at the top of the list among a series of factors that I want to talk about. Debt facilitates other labor abuses because indebted workers are afraid to complain if their rights are violated because they're worried that they're going to get fired and lose the job opportunity before they have any opportunity to repay what they owe and start earning the money for their families that they came for in the first place. But recruitment debt is not the only reason why abuses flourish. And we often focus on recruitment debt and talk about the need for the migrant origin country to address it. But in fact, there's a lot going on in the country of production that creates risk factors for forced labor as well. And many of those things are affirmative policies of the production country government that create conditions that make forced labor more likely. And those policies include things like tied visas, that is to say, a visa that only authorizes the worker to work for a single sponsoring employer. The worker is not able to change jobs when that happens. If the employer to which the worker is assigned turns out to abuse them, they have no choice. Or rather, their choice is to deal with the abuse, or if they're able, and in distant water fishing, they may not be able to turn around and go home and then have to repay the debt and the interest that they owe. Another risk factor that arises from policies and laws in the destination country is laws that grant lesser rights to migrants, that allow employers to work them for longer hours, to pay them less than local workers, and to deny them access to local protection mechanisms. And then the fourth risk factor I want to highlight is that in countries of production, migrants often have barriers to communication and redress. And in seafood, particularly distant water fishing, the lack of Wi-Fi on vessels and the lack of the ability to have unions recognized as their representatives and have access to their unions while on a vessel increases the risk of forced labor because those boats may be out for many months, they may be out for a year, and whatever's happening on those boats there is no way for them to communicate it to their union or their families or the government if they don't have access to Wi-Fi. So if this and the interactions in the supply chain are how forced labor arise among migrant workers in a supply chain context, what do we know about what works to fix those problems? And I've been talking in general here about common relationships in the seafood supply chain, but I want to turn now to talking specifically about Taiwanese distant water fishing and about Indonesian migrant workers who are the majority of the labor force in the Taiwanese fleet. The temptation when we talk about solutions is to treat abuses that happen on the vessel and abuses that happen during recruitment as completely distinct. Quite often you hear discussions that say, if we're talking about recruitment abuses, that's Indonesia's problem. That's a problem that has to be taken care of at that level. And when we're talking about abuses on the vessel, that's Taiwan's problem. That has to be taken care of by Taiwan alone. But what my research and the research of many others has shown is that because forced labor results from the entire business model of the product and human supply chains together, from the very top to the very bottom, the response has to be supply chain wide as well. So to effectively address forced labor requires that we keep this whole supply chain in mind and seek to influence the behaviors and business models that drive forced labor, starting at the top, also focusing at the middle, and looking in addition at what's happening in the human supply chain. At the top, it's essential to address the fact that the current business models of retailers and brands in countries of consumption, like the United States, pits seafood producing countries against each other on the basis of cost and creates the cost pressures in countries of production that drive forced labor. And those lead firms must be a part of any solution to the problem of forced labor in supply chains. They have to be required to change their contracting and sourcing practices. And I come from a country, the United States, that is completely failing on that front. I know the title of this presentation was 3 Countries' Perspectives on How to Deal with Forced Labor. I make no pretense that the United States is effectively dealing with forced labor either in as driven by its retailers or brands and as occurring in other countries, or as occurring in the United States in our own export industries, for example, in agriculture, where we rely on migrant workers who face conditions of forced labor, and the US government is doing very little to stop that. So I want to be very clear about that at the outset, that I come from a country that is failing to address forced labor effectively. But I do want to note that other places like the European Union, for example, is moving toward a model of mandatory human rights due diligence that is an important step, in my view, in requiring lead firms to take responsibility for the ways that their business practices produce human rights abuses among the workers at the bottom of the supply chain. So that's the top. In the middle, in countries of production, such as Taiwan and many others, there are critical roles for both the government and supplier firms to play in changing purchasing, employment, and recruiting practices that drive forced labor. And I'm going to turn to that shortly. Policies that both the government and suppliers could pursue in Taiwan to reduce the risk of forced labor. But first, I want to say that at the bottom, and here I mean in the lives of workers on the vessels, it's rarely discussed that the workers themselves have an important role to play. And it's essential that they have the right and the support to organize and take action themselves to address the abuses that they face. Now, forced labor, I think we all recognize, occurs on a continuum. It's not an on-off switch, but a continuum of practices. And I recognize, of course, that in some places it's so severe or occurs in a country that has no right to trade unions or no rights for migrants to join trade unions, that it really is impossible for migrants to organize in a traditional union format. And this is even more the case where the forced labor is state-sponsored. What I'm really talking about in the supply chain here is private forced labor, where the government is the sponsor of the forced labor. Then organizing by workers is rarely a viable alternative. But in other places, workers have more agency. And that's especially the case in democratic countries like Taiwan, where there are migrant trade unions and there are civil society organizations that support migrants as they seek to organize. And in those circumstances, and I'll talk a little bit more about this in a moment, it's critically important that firms and the government involve migrants and their organizations in efforts to prevent and remediate forced labor. So let me turn now to what I know is a very urgent set of questions about the U.S. forced labor import ban. In the United States, as I just said, the U.S. government has been deeply reluctant to hold its own firms responsible for their role in producing and reproducing forced labor in supply chains. However, at the same time that the U.S. government shields its own firms from responsibility for forced labor, it has been one of the most active governments in the world in using trade bans to penalize companies in other countries for forced labor. There is much more I could say about U.S. hypocrisy in the world of forced labor, but that's a lecture for another day. Since I know there's a lot of interest in the forced labor import ban in Taiwan now because of the recent imposition of a ban at Giant Bicycles, I want to draw on a very recent research project of mine to offer an explanation of how the principal U.S. import ban works and how the U.S. government has applied it over the past 5 years. And then I want to conclude by talking about approaches the Taiwanese government and firms might take to prevent and remediate forced labor with this supply chain model in mind. Okay, so let's talk about the U.S. forced labor import ban. This is a provision in U.S. trade law that allows the government to ban the importation of particular products where it believes that the workers who were involved in the making of the product faced forced labor. The provision, as it said, is in Section 307 of the General U.S. Tariff Act, the General U.S. Law on Trade. Until pretty recently, this law has been on the books since 1930, but until 10 years ago, a loophole meant that the law very rarely could be applied. But in 2016, U.S. Congress amended the law, and since then, the U.S. government has become much more active in imposing bans. So here's how the mechanism works. The agency in charge of enforcement is the Customs and Border Protection Agency. I would just note parenthetically that that's an agency with a dual mission. The customs side enforces trade law. The border protection side enforces immigration law, at least at the U.S. border. So for somebody like me whose specialty lies at the intersection of immigration and workers' rights, this is a particularly relevant agency. But the departments are completely divided from each other. Trade unrelated in its day-to-day workings from immigration. So CBP is the short form of Customs and Border Protection. The way the law works is that anyone and anywhere in the world can go on CBP's website, click a button, and file a petition with the US government, offering evidence of forced labor at a particular company, or more generally, in the harvesting, manufacture, or production of a good in a particular country, across that country, and ask for a ban to be imposed. Also, as I note on the slide, the US government doesn't need a petition to take action. So it can just start its own investigation, sometimes presumably for cover. If it wants to do that, it will go to an advocacy organization in the US and ask them to file a petition so that it can say it's pursuing a petition. What happens next is only sometimes the case. So the next step is supposed to be that CBP investigates. Nobody on the outside really knows how things work in CBP, but it appears that a number of petitions don't receive serious investigation, but some do. As I said before, the government can also investigate without having received a petition. Third, CBP, if it finds upon investigating that there is reasonable suspicion, that's the term the standard that it seeks to meet, reasonable suspicion that the allegations of forced labor are true, it imposes a withhold release order, or WRO, on the good. The reason it's called a withhold release order is because the goods are at the border at that point, and the government is withholding their release into the United States. So basically, the government is holding them at the border. And a withhold release order bars the entry of any good covered by the WRO into the United States from the moment it's imposed until the government lifts the ban, if it ever does. That WRO is going to remain in place until CBP finds that the forced labor has been remediated. So in the decade since the loophole was closed, CBP has imposed not so very many bans, but in a wide range of countries and sectors. The total number of WROs issued in the past decade is only 45. Including every country where it's been issued all around the world. More than half of those have been issued against mainland China. The next largest cluster is against businesses in Malaysia, and the next largest cluster are against fishing vessels. Mostly, it's scattered across countries and across industries, as this slide illustrates. There's a resource I wanted to share with you, which CBP makes public, called the Forced Labor Dashboard, or the WRO Enforcement Dashboard. If we could put up that website. It's this, yeah, that's it. So if you scroll down, you can see, sorry? Yeah, this is perfect. You can see, and anybody can go on this website, and if you don't mind putting the URL in the chat so people can access it, this is where the US government publicizes its WROs. I will say right off the bat, this is not accurate. So do not get statistics from here. They're actually linked to a database. If you scroll up, you can see where that link is. That may be, I haven't looked recently at the actual database, that may be more accurate. Think of this as a very general snapshot and not a statistically correct picture, but it is put out by the US government. Okay, if we can go back now to the slide I was on. Yeah, thank you. As I said here, the bulk of the bans have been imposed under Section 307, have been imposed against mainland China, but there is also a more recent law, not reflected on this slide, the Uyghur Forced Labor Prevention Act, which since 2022 specifically forbids the import of goods produced with Uyghur forced labor in China. And many more bans have been issued under the Uyghur Forced Labor Prevention Act than have been issued under Section 307. Or rather, I should say many more goods have been banned, both because CBP is putting most of its resources toward enforcement of the Uyghur Forced Labor Prevention Act, and because the way that act is structured creates a presumption of forced labor that a company has to rebut when goods are made with Uyghur labor. And so, as opposed to Section 307 and WROs, which require a demonstration to convince CBP that there's reasonable suspicion of forced labor, the Uyghur Forced Labor Prevention Act assumes there's forced labor and a company has to rebut that. But setting aside the Uyghur Forced Labor Prevention Act and returning to Section 307, many other countries' goods beside these most targeted countries have been focused on as well. Mexico, Malawi, Japan, and of course, the most recent ban, as I referenced earlier, was against giant bicycles in Taiwan. Banned products, this isn't even, I pulled this, I went through all their data and pulled this list of products that have been banned, but there are many more products as well. So you can see it is garlic, silica, palm oil, sea salt, artificial flowers. It's very wide in terms of the number of industries that have been impacted. So here is the point in the presentation where it would be fantastic if I could give you a rational account of how the US government decides when to put bans down and where to do that. I can't do that. Many petitions are filed. Few bans are issued. The process is not transparent. CBP does not publish any indication of what it has learned through its investigation or why nor does it give any justification of why it does or does not impose a ban in a particular case. And other than the geopolitical issue, where the US government has put most of its enforcement resources toward banning goods from mainland China. And I should say, according to accounts that seek to assess what percentage of forced labor occurs where, 4% of the world's forced labor arises in mainland China, and 57% of these bans are against mainland China. And then there's the Uyghur Forced Labor Prevention Act. So the conclusion from the outside, I'm on the outside, has to be that there is a geopolitical strategy involved in the imposition of at least some of these bans. But other than that pattern, there have been very few patterns that I or advocates have been able to discern about where a ban is going to be imposed. Where CBP has recently offered more guidance, though, is on what it is looking for from a firm in order to lift a ban that it has put in place. So what does a firm have to do to get a WRO removed once it's already been replaced? In other words, on the previous slide, whoops, I've lost slide control. Thank you. In the remediation phase. So what I want to highlight here is, according to its recent statements over the past 3 years, the US government is increasingly looking at something that I mentioned briefly earlier in deciding whether to lift a ban, and that is the level of worker representation through unions or other organizations. For just one example, in 2022, CBP lifted a WRO on an Indian garment factory after advocates demonstrated that workers were represented by a union and that the the workers' agreement with the union and the brand that sourced from the factory where forced labor had occurred, that those agreements had remediated forced labor at the factory. And then the US government lifted the ban and issued a press release that explicitly referenced the work of the unions and civil society organizations as central to remediating forced labor in that context. A few months later, the US government published a document endorsing freedom of association and solutions to forced labor that center workers and their organizations. Now, those statements came under the Biden administration, which had a focus on worker organizing as a part of its domestic and foreign policy. We no longer have the Biden administration in the United States, but more recently, under the current Trump administration, in August of this year, the US government issued an advisory document for firms that are subject to a WRO, explaining what CBP looks for as evidence to lift a WRO. So if we could put up the second webpage, I just wanted to show and then share the link for that document, which I think might be of interest to firms in Taiwan. Yes. So this is the document. If you scroll up a tiny bit more, so it's the Office of Trade Forced Labor Division, CBP, Withhold Release Order and Finding Modifications Guide. And it goes on for a number of pages, offering guidance for modification. If you wouldn't mind also putting that link into the chat, I would appreciate it. As what I want to focus on is that in this advisory issued by the current administration, the CBP emphasizes the importance of an active role for workers and unions in combating forced labor. So to read a couple statements from this advisory, when CBP is considering whether to lift a WRO, evidence of the following is relevant. And I quote, a collective bargaining agreement with benefits for workers that are above the minimum legal requirements. Next, the percentage of workers in worker-led organizations and covered by enforceable collective bargaining agreements. Another thing in the document, evidence of election of worker representatives. Another thing, evidence of engagement with civil society organizations that engage with workers. And it seems to me that this is important information for firms and governments alike. Although the advisory is directed to firms which are seeking to get a WRO in place, lifted, I think it's likely that the advisory document also offers insight into what CBP looks at in a given context before deciding whether to impose a WRO. And when I refer to context here, I mean both to the specific firm under investigation and the policies of the government in the country where it's located. Where the government has involved migrant unions in its effort to address forced labor, and where at a firm level, migrant workers have organized and negotiated enforceable rights under a collective bargaining agreement, CBP is telling us that it may take these things as evidence of effective prevention of forced labor as well as remediation. Finally, let me turn to key steps that the government of a country such as Taiwan might want to consider to proactively prevent forced labor in export industries, supply chain industries that rely on migrant labor. And these recommendations track the points I made earlier about the risk factors for forced labor. So debt as a problem, the response here is what's called an employer pays regime, to require that the employer, rather than the worker, pay for recruitment costs and fees. To respond to the issue of tied visas, policies that eliminate tied visas or grant migrant workers the right to change employers if their rights have been violated, if they find themselves in an abusive situation. In response to the lesser rights issue, government policies that mandate that migrant workers receive the same wages and treatment as local workers and create functional mechanisms to enforce that mandate. And then finally, in terms of barriers to communication and redress, mandates, for example, requiring Wi-Fi on vessels so that workers can get help from their union in real time, the creation of effective grievance procedures, and formalizing a role of migrant worker unions in grievance resolution are all important steps. And in fact, the government of Taiwan has already moved in the direction of some of these policies, but there's more that could be done and should be done to improve the conditions of migrant fishers and make sure that their rights are respected. And I want to end by saying that one important forum for action would be for the government to enter into memoranda of understanding with key migrant origin countries such as Indonesia to commit to jointly taking steps to prevent forced labor in specific industries. For example, distant water fishing. Because coordinated action across borders allows governments to address problems in the human supply chain and the product supply chain as one. And I hope I've been convincing that in fact they are one, that the system functions as a whole. And I'll just conclude by putting up this slide, again reflecting my research on what are best practices for labor migration memoranda of understanding. There is more I could say about this, but I've already talked for quite some time, and I really look forward to hearing from my colleagues on the panel and to the conversation that we'll have in what follows.